Hello, this is Sylvia Hetzel, and welcome to this week's current events video. My colleagues Jennifer Bort, Megan Emery, Rick Hansen, Young-In Kim, and I will be talking about a European privacy law passed 2 years ago, which has prompted great debate on both sides of the Atlantic ever since. The law has come to be known as the right to be forgotten, and in this video, Young-In, Rick, Jen, and Megan will explain what the law says, how it came to be, and why we believe that the First Amendment of the United States Constitution makes it basically inconceivable for a similar law to be adopted in our own country. So let's go to Young-In, who'll provide some background on the 2014 European Court ruling, which established the right to be forgotten.
Hi Sylvia. I'm going to provide a bit of background on the event that triggered our current conversation on the concept of the right to be forgotten. The concept has actually been a point of discussion in the European Union since the Data Protection Directive was adopted in 1995, but it wasn't legally confirmed until more recently in May of 2014. That year, the Court of Justice of the EU ruled in favor of a Spanish citizen who sued in the Spanish courts to have personal data removed from the newspaper's website as well as from Google search results. While the Spanish court ruled that the newspaper would not have to remove the data in question, the EU Court of Justice ruled the following when it comes to search engines. First, individuals have the right, under certain conditions, to ask search engines to remove links with personal information about them. These conditions include information that is inaccurate, inadequate, irrelevant, or excessive for the purposes of data processing. It's important to note that removal requests are handled on a case-by-case basis and that the right to be forgotten is always balanced against other fundamental rights such as the freedom of expression and of the media. Second, the court ruled that as search engines are controllers of personal data, companies such as Google have a responsibility when handling this data. Third, the court ruled that EU rules apply to search engine operators operating within the European Union, even if the physical server of this company that's processing data is located outside of Europe.
Thanks, Young-In. Now Rick will explain why we believe that a similar law could never be adopted in the United States.
Thank you again, Sylvia. In 1998, a Spanish newspaper published 2 public auction notices stating that a property owned by Mario Costeja Gonzalez would be sold to cover his debts. 12 years later, Gonzalez filed a complaint to restrict discovery of this newspaper article. Local authorities worked with the continent-wide regulation agency and agreed that Google should stop retrieving the old article whenever Gonzalez's name was searched. However, the Spanish newspaper did not have to remove the article. The articles were public. They were reported correctly by the newspaper at the time. What is of public importance and who gets to decide? The information will always exist through original publishers. Why does a search engine have to censor results and allow challenging or delayed discovery? In the United States, the approach has been to provide protection for certain categories of information. For instance, Congress has passed laws prohibiting the disclosure of medical information, educational records, and even video store rentals. The American regard for freedom of speech reflected in the First Amendment guarantees that the Gonzalez judgment would never pass U.S. law. There are sad, powerful stories about a need to adopt RTBF. For instance, 10 years ago, an 18-year-old woman was killed in a gruesome car accident. The police had taken photographs following standard protocol, but 2 employees later admitted to sharing the photos as a Halloween prank. Spreading rapidly, there was no end, and the grieving family had to stay away from the internet. These images should never have been publicly released, and the family has a right to cease the spread, but it does not appear possible. A potential solution from the Garcia Murillo readings: should we acknowledge and accept that humans are imperfect? Mistakes happen? Should we move towards a more realistic expectation of human behavior? Reducing the shock associated with outrageous digital mistakes might help lessen their impact. But does one right trump another? In recent years, many have made the same kind of effort, from actors who don't want their private photographs in broad circulation to ex-convicts who don't want their long-ago legal troubles to prevent them from finding jobs. Despite the varied circumstances, all these people want something that does not exist in the United States: RTBF, or the right to be forgotten. Here in the U.S., we oppose any hint that press and speech freedoms might be restricted. Do we put up with our mistakes in different ways? Do we continue to build a better future and a better country by consistently moving ahead, or do we hyper-focus on the past like old Europe?
Jen will help us put the European and U.S. positions into perspective by drawing attention to some fundamental cultural differences which exist between the two.
Thanks, Sylvia. When talking about the right to be forgotten, it's important to keep in mind the cultural differences between the European Union and the US, especially when considering the reasons why a right to be forgotten wouldn't work here in the US. The right to be forgotten has its roots in a French law which translates to the right of oblivion. This law allows criminals to ask for their record to be deleted so they can get another shot in society. In the US, however, that criminal record is actually protected by the First Amendment. Here in the US, we value free speech over privacy. The opposite is true in the European Union. The right to be forgotten is part of the right of personality there, a European right of the moral and legal integrity of a person not to be infringed upon. This points to a larger difference in overall definitions of privacy in Europe and the US. In Europe, something called dignitary privacy prevails. This is privacy as an inviolable individual right. Here in the US, we value something called resource privacy, which refers to bigger societal interests such as freedom of expression and cost to businesses. So these differences help illustrate why a right to be forgotten wouldn't work here. It should be noted, however, that from a public perception angle, interestingly, the public in both regions largely have similar views on privacy, particularly when it comes to online privacy concerns. This is part of the reason it's such an interesting, divisive issue.
And finally, Megan will bring it all together.
Thank you, Sylvia. The complexity of the cases presented by my associates today has not been lost on U.S. citizens, and an interesting review of our cultural differences, along with several cases, took place recently on March 18, 2015. The nonpartisan nonprofit Intelligence Squared hosted an Oxford-style debate in New York to discuss whether the U.S. should adopt our own right to be forgotten law. Before the debate began, the audience was polled on whether they agreed the U.S. should adopt the right to be forgotten online. 36% agreed with the motion, 26% were opposed, and 38% were undecided. The debate consisted of 3 rounds and raised such interesting ideas and questions as, do you have a right in determining what data is collected, kept, and sold about you? If the right to be forgotten law suppresses true information, is it censorship? And since the root information is not erased when right to be forgotten takes place, only the link, the ability to easily get to the information is what's actually being erased, not the past. When the debate concluded, 35% agreed with the motion that the U.S. should adopt a right to be forgotten law, 56% were opposed, and 9% were still undecided. This resulted in the opposed being declared the winner of the debate. Ultimately, it seems that as a society, we agree with debater Jonathan Zittrain, who described the right to be forgotten as a poor solution to a very real problem. While the right to be forgotten may be a solution to balance privacy and access to information in Europe, it will take more analysis and discussion to determine what should be done in the U.S., where we clearly value our freedom of speech above our right to privacy. Back to you, Sylvia.
So in the end, what kinds of legal rights do we or should we have to protect our privacy as more and more information is available about us on the internet, and once it's there, it doesn't go away? What, if anything, could we do to strike a balance between the First Amendment on the one hand and privacy protection on the other? There's some food for thought, and we look forward to hearing your comments and opinions in the discussion that follows. Thanks.